Sir?
Yes, sir. Excuse me.
Okay, this is cause number JT979563. This is a hearing in regard to a motion to challenge subject matter jurisdiction filed by Christopher Robert Weiss. Mr. Weiss is present. The state is represented by Brandon Carr. Okay, Mr. Weiss, let's hear what you have to say.
I guess the first thing I'd like to know is there evidence of a complaining party in the record?
Sorry, sorry, what was your question?
Is there evidence of a complaining party in the record?
Mr. Weiss, the procedure is not for you to ask questions of the court. The procedure is for you to present whatever it is you wish to present with regard to the motion which you filed. The court gave you a hearing, which is your hearing.
Well, the burden of... excuse me. The burden of proof isn't on me.
On this motion it is.
No, for subject matter jurisdiction, the Supreme Court has upheld that the burden of proof lies solely on the party bringing the matter, and that would be, I'm sorry, what did you say his name was?
Brandon Carr.
Mr. Carr?
State can speak, that's fine.
Sorry.
The state can present something if you don't mind at this point.
Gentlemen, it doesn't make any difference to the court how you present what you want to present, but this is Mr. Weiss' motion, so if you want to defer to the state, you can certainly do that. Is that what you're doing?
Well, I'm sorry, I don't know who he is. I haven't seen his bar card. I do have your oath of office in record with me. I don't know him.
Mr. Weiss, the court knows who he is, and the court knows that he's an attorney licensed to practice law by the state of Texas. That is sufficient for the court. Now, what do you wish to present with regard to your motion?
I'll defer to him because this burden of proof lies on the state here.
So you don't wish to present anything to the court in regard to your motion, is that correct?
Other than the fact that I don't believe there to be a complaining party in the record, I don't see where the burden of proof lies over here. I did not bring this matter. I'm just here to answer for it.
This is not a hearing on the merits. This is not a hearing. This is not a trial. Don't overtalk me. This is not a trial on the merits. This is a hearing on a motion which you filed to challenge the subject matter jurisdiction of the court. And the court now, for at least the third time, is inquiring as to exactly what evidence you wish to present to the court, thereby challenging the subject matter jurisdiction of this case.
I do believe that's in my motion, sir.
Sir, you don't understand the procedure here, evidently. It is your opportunity to present whatever you wish to present in support of your motion. Do you have anything you wish to present?
I'm not. You're right. I guess I'm not understanding because it does. I mean, it is clear from the Supreme Court's rulings that it is on this.
Supreme Court ruling.
When a judge knows that he lacks jurisdiction or acts in the face of clearly valid statutes expressly depriving him of jurisdiction, judicial immunity is lost. Rankin v. Howard, 1980, 633 F. 2D 844.
Is that cited somewhere in your motion?
Yes, sir. On page 3. Well, there are actually 6 sites there, sir. And also, in any judicial proceeding, the moving party has the burden of proof of demonstrating that the court has subject matter jurisdiction over the matters and parties before it. Scott v. Sanford, 60 U.S. 393, Security Trust and Company v. Black River National Bank, 187 U.S. 211, 2002.
So you're wanting the prosecutor to state what the subject matter jurisdiction is as a principle of the state?
Well, the burden of proof is I'm understanding the Supreme Court rulings is that the burden of proof lies solely on the state to prove that the court has subject matter jurisdiction.
Do you have anything to present, Mr. Clark?
Yes, Your Honor. Section 10-1 of the City of Fort Worth Code says that the City of Fort Worth has jurisdiction concurrently with the Justice Court in any precinct in which the City of Fort Worth is located in criminal cases that arise within the territorial limits of the city and that are punishable only by a fine. This citation was issued on Hewland Street at 3100 South Hewland Street. It's also punishable only by a fine because we were charging Mr. Weiss under Section 521.021 of the Texas Transportation
I object to the use of the Transportation Code.
Well, you can voice that objection. We're not in a trial. You can raise your objection in a moment. This is his opportunity. You ask him to do this, this is his opportunity. So be quiet while he does it.
So in order to comply with the city code, we're charging him under 521.021 of the Texas Transportation Code, and 521.025 says this is an offense that's a Class C misdemeanor, punishable by a fine not to exceed $200. It meets the requirements of the Transportation Code, and it meets the requirements of the City of Fort Worth Code to show that we have jurisdiction.
Mr. Weiss responds.
I object to the use of the terms Transportation Code. I was not engaged in transportation at the time of this alleged offense. Can he please state where he said the address of a place, of where that was located? Because I was in a Tom Thumb parking lot.
The Elton Road, 3100 South Hewing Street.
I was in a Tom Thumb parking lot. I don't know if that's the address to that location or not, but I was in a Tom Thumb parking lot.
What else do you have, Mr. Weiss, to challenge the subject matter jurisdiction of the court?
Other than the fact that the state has the burden of proof here to prove beyond a shadow of a doubt that the court has jurisdiction over the matter.
Is that it?
Yes, sir.
Anything else from the state?
No, Your Honor.
Mr. Weiss, your motion is in total overruled. The case will be set for trial. You can send a notice in the mail when you appear. Thank you very much.
Am I able to appeal this, sir?
You can take whatever steps you wish to take.
Okay, for the record, I'd like to let the court know now that I intend to appeal this.
And the court expects that you will follow the rules of procedure with
Yes,
regard to that appeal. Thank you very much.
Thank you.
Mr. Weeks, you want to present your driver's license by law and required to consent at this time. If you want to present proof of that. If you don't, when you want to go forward for trial, you're allowed to do that too.
I don't have a driver's license.
Okay. Then we'll just go ahead and proceed.
Thank you, sir. Have a wonderful day.